Today we start off with Bouvier, or Bouvier. Last time we left off with injunction. We will no longer be using colorable terms. Red is the flag for the Moors. We do this for the children so that they may grow. Color, or colorable, or color, or colorable. What is apparent is prima facie correct or justified. Color in law is a metaphor for the appearance of presumptive legality and truth in an action or argument. Thus, a colorable claim is one that has a bona fide appearance of legality, whether it ultimately proves to be correct or not. Thus, color of title is the claim of ownership based on a title. An act under color of state law is an act authorized by state law, and the colorable claim that is apparently color of law, valid under the facts and the law. Color in these senses suggests that the assertion is presumptively true. Although it might not be found true on closer analysis, color, whether express color or implied color, once had a more formal significance in pleadings under the writ system, in which color was sometimes more a pretext than a good faith expectation of the law. But this sense is now largely obsolete. See also right, legal right, color of right, claim of right, or color of right, color of law. No more colorable terms as expressed in the beginning of this video. Bouvier. Court of record. A court in which proceedings are recorded and binding as law. A court of record is a court created as a court of record, required to maintain records of its proceedings for the purposes of review and for purposes of binding the parties to actions in that court to the matter recorded. All courts with criminal jurisdiction are inherently courts of record, unless they are legislatively created not as courts of record, as are certain justice courts. To be a court of record, the court must be given a specific jurisdiction and be provided with a judge or justice, an obligation to maintain records, and a seal or a clerk whose authentication functions as a seal. See also record or record. Records are everything in your case. If you've heard Taj, Menard, Bill, or Queen Valhalla Bay, all the stuff they talk is real. So you better stop using colorable terms and use Bouvier, because we are no longer using Black's law. We are no longer using colorable terms. We will use Bouvier Law Dictionary, Compact Edition, based on the classic Law Dictionary by John Bouvier, the Law Dictionary of John Marshall, Daniel Webster, and Abraham Lincoln, the Wolters Kluwer Bouvier Law Dictionary, Compact Edition, provides clear, accurate definitions, explanations, and examples that convey what each word or phrase means, its context and its role, and the role it plays in modern-day practice and scholarship. We're not saying this dictionary is not correct, but you may need the two to make comparisons, as my brothers and sisters have expressed in their videos. Alright, today we're going to discuss fiduciary. A fiduciary is a person in whom another reposes special confidence and reliance. A fiduciary is a person with a responsibility that requires a higher level of care by the person and trust of others than the usual commercial or social relationship. A fiduciary must put the interests of the person or entity relying upon the fiduciary above the fiduciary's own interests, and the fiduciary usually has an affirmative duty to act for those relying on good faith of the fiduciary rather than merely a duty not to act negligently. Fiduciaries must have or acquire sufficient knowledge and skill to carry out the office in good faith, must act affirmatively to avoid waste or loss in managing assets, and must act to inform the other in many circumstances. Certain positions inherently require fiduciary duties, particularly a trustee to a beneficiary, an accountant to a client, a doctor to a patient, a lawyer to a client, a corporate officer to a shareholder, an investment manager to a client, etc. Fiduciary duties do not admit to the definition or limitation of their enforcement is occasionally a matter of contract or fraud, but more often a matter for equity. Famously, the term fiduciary is derived from fides, or faith, marking both the faith others must have in the fiduciary and the good faith owed to them. See also influence, faith, jurisdiction, equitable jurisdiction, fiduciary, fides, fiduciary law, see trustee, fiduciary law, successor, trustee, fiduciary duty, the heightened duties of care owed by a fiduciary to the principal. Fiduciary duty encompasses a range of obligations that a fiduciary owes to the person or entity who relies on the fiduciary. The duty is both general, in that the fiduciary must exercise good faith, placing the interests of the principal above the fiduciary's interests, and specific in that fiduciary has a duty of loyalty to avoid conflicts of interest, to use the fiduciary's best efforts, and to avoid misrepresentation. Most actions for breach of a fiduciary duty require clear and convincing evidence of a violation of this heightened expectation of trust. The recognition and enforcement of its fiduciary duty is a matter of equity, jurisdiction, and even in courts of general jurisdiction, such matters are subject to equitable pleading standards, including equitable principles of standing, and to equitable remedies. See also diligence, due diligence, equity, and equitable.